Hi there, how are you doing today? My name is Mutiawa Conrad, a lawyer and a private law tutor. And basically today we are going to be looking at criminal law and the offense of attempted rape. However, before we start our class, please make sure that you subscribe, you like and share this channel. Also ensure that you turn on the notifications so that you're always able to be up to date with my videos. Also, for students that are interested in private law tutorial sessions where you may need some polishing, you may need some private personal assistance, please feel free to contact us. Our number is down in the description box. You can always find us. So this tutoring, this mentoring really helps, and it really has a direct impact onto your academic grades. So let's start right away with the offense of attempted rape. And in this video, we're basically going to be looking at the definition. We'll also examine the law that provides for the offense. We'll also look at the ingredients of attempted rape. We'll also proceed to make an analysis of what courts have held on this offense and what the state must prove in court for them to be able to secure a successful conviction for this offense. We are also going to look at the defenses. Is it possible that an accused person for attempted rape has any possible defense at their disposal? So we'll also be looking at the defenses that are available for someone who is charged for attempted rape. So ladies and gentlemen, let's kick off right away with what really is provided for under the law and what does the law provide on this offense. So you look at section 125 of the Penal Code Act. It provides for the offense of attempted rape, and then the punishment for that offense is also under the same section, which is imprisonment for life. So that is the punishment you'll get in case a criminal court convicts you for the offense of attempted rape. So let's quickly proceed to look at the ingredients of this offense. What must prosecution or what must the state prove in court for them to be able to get a full conviction? So the first ingredient to prove is the attempt to have sexual intercourse with the complainant. So there must have been an attempt, okay, by the accused person to commit a sexual intercourse with the complainant. The second ingredient or the second element of the offense is the lack of consent by the claimant. So again, just like we saw under rape, there must be the lack of consent, because the moment there is consent, then it cannot be attempted rape. Then the last ingredient, which is the third one, the accused must have attempted to have sexual intercourse with the complainant. So again, there must be that attempt to have sexual intercourse. So those being the ingredients, let's now proceed and then we examine them a little bit more. Let's look at basically the attempt to have sexual intercourse. Let's examine it a bit more and we see what the law provides and what are the principles governing the same. So on the aspect of attempt to have sexual intercourse, I invite you to look at section 386 of the Penal Code Act. It actually defines an attempt as a manifestation of intent to commit an offense by an overt act, which act is not fulfilled. So that is basically what section 386 is defining an attempt as. It's a manifestation of intent. So the accused person must have manifested. They must have indicated. They must have done an act to show the intent, okay, to commit that offense. It's very important. And they must have shown the intent by an overt act. Now, an overt act is an act that is very close to the act, okay? And under the Penal Code, it also actually defines what an overt act is. Please look at it. But in summary, an overt act is an act that is very close, very, very, very close to the main act. That is what we mean when we say an overt act. And also of interest is section 386, subsection 2 of the Penal Code Act, which provides that it is immaterial, save as regards punishment, that the accused person is prevented from fulfilling his or her intentions. So the fact that an accused person has been prevented from fulfilling the intentions of attempting to rape, or in fact to rape, in itself is immaterial. It is immaterial. The only situation where it becomes material is on punishment after conviction. That is when court can look into that and then it considers it in sentencing. But save for that, the position of the law is that it is immaterial, save as regards punishment, that the accused person is actually prevented from going on to commit the offense of rape. Let's also proceed to look at a very interesting case on attempted rape, and that is the case of Ara versus Haruna Ibrahim. This is a case of 1967 High Court HCD case number 76. Now, in this case, court held that for conduct to constitute an attempt, the impunged act has to be more than just preparation. Okay, it has to be an unequivocal step towards the completion of the crime, which, but for the interruption or interference, would in fact have occurred. So here what we are saying is that when we are looking at attempted rape, okay, in itself, you know, for the conduct, for us to say in law that the conduct actually constitutes an attempt in itself to rape, okay, the impunged act has to be more than just preparation. So if it is mere preparation, okay, let's take for example, if there is gentleman A who was going to rape a lady, let's call them Lady B, the mere fact that they have just been found maybe in the room with a man who has removed their trousers, okay, or maybe who has gone maybe to the bathroom to first shower before they can involve themselves in such an act, that preparation in itself is not sufficient for it to constitute an attempt. So if it is an attempt, for that act, you know, that act must, okay, for it to constitute an attempt, for us to say that indeed there has been an attempt to rape, okay, that act has to be more than just mere preparation. That is why we are talking of an overt act. And we say that an overt act is that act that is very close to the main act, okay? Assuming gentleman A was found on top of a lady, the gentleman is naked, the lady is naked, and the man is just about to penetrate the lady. So such an act can amount to an overt act. It is an act that is very close to the act, that hadn't anyone interrupted at that material time, that indeed the same would have resulted into an actual rape. So that's what we mean when we say that there must be an attempt to have sexual intercourse. And of course, the ingredient of lack of consent, there must not be consent. So the lady must not have gone on to give consent. The moment there is an aspect of consent, then it negatives, okay, it negatives the mens rea as being guilty in a sense. So basically those are the ingredients, and that is the examination and the principles governing the same. We are now going to proceed finally to look at the defenses, okay, the defense to attempted rape. What are some of the defenses that you can actually raise? Now there's the defense here you can raise for attempted rape is belief in consent, okay, belief in consent, okay. I know to most of you this is really very new. You thought that maybe there are not any defenses on attempted rape, but it's not true. You can actually raise the defense of belief in consent, and this defense actually is cemented by law. And I invite you to look at the case of DPP versus Morgan and 3 others. It's a case of 1976 SC 181. In this case, the House of Lords held that when a defendant has sexual intercourse with a woman without her consent, but genuinely believing nevertheless that she did consent, she was to be convicted. She was not to be convicted of rape. So again, this is what I'm saying, because if let's say a man called A is going on to commit attempted rape, but they genuinely believe that the lady was actually consenting, they honestly believe, maybe the lady said yes, okay, and the gentleman actually believed that the lady had consented, okay, maybe from the actions of the lady, they were indicating some bit of consent although she was a bit maybe hesitant, and the man really believed that this lady was actually consenting, and they genuinely believed that from the bottom of their heart, then such a defense can always be raised on such an offense of attempted rape. Authority, I've already given you the House of Lords decision in DPP versus Morgan and 3 others, a case of 1976, AC page 182. Please go and look at it, examine the whole case, read it in detail, and you'll be able to get even a better understanding of the same. So ladies and gentlemen, that was all for today. Please do not forget, subscribe, like and share this video with your colleagues so that they are able to benefit. Also, students interested in private law tutorial sessions to have an expert to polish you privately in holidays, at school or anywhere, please feel free to always contact us. Our contact is down in the description box. Thank you very much. We meet in another class next time. Bye-bye.